Hello and welcome to episode 103 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Baron, Executive Director of the CCF. And in today's episode, I'll tell you about Canada recognizing Palestine and what the rule of law and international law principles would tell us about the appropriateness of that.
And I'll tell you about the Mark Carney Liberals' new hate crime bill, C9, which introduces a whole new slew of freedom of expression problems.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about the Carney government poking the bear with an interpretation of the Notwithstanding clause that I don't think anybody saw coming. So, as astute listeners of Not Reserving Judgment will know, the Supreme Court will hear this monumental case next year about the Notwithstanding clause. That is Section 33 of the Charter, which says that statutes invoking this clause will stand for 5 years at a time unless renewed, regardless of Sections 2 to 7 or 15 of the Charter. So, notwithstanding things like the guarantee of freedom of expression or freedom of religion or equality rights. And Section 33 has always been controversial for pretty obvious reasons. Some people argue that any use of it is by definition overriding constitutionally protected rights. Others argue that it's a necessary tool for legislatures to define the content of rights in those cases where judges are liable to get it wrong. And it's so controversial that Ottawa has never used it in more than 40 years, and the provinces outside of Quebec have been pretty judicious in its use as well. One example of it being used more recently, though, is Saskatchewan using it to shield their law that blocks kids from changing their gender pronouns in schools without parental consent, which courts are likely to find violates equality. And Alberta, they famously used it back in the year 2000 to try and define marriage as between one man and one woman. And more recently, Alberta has said that they will use it to protect their laws regulating gender pronouns in school, regulating trans women in women's sports, and barring doctors from providing treatment such as puberty blockers and surgeries to those under age 16. So the case that's going to the Supreme Court, it's called English Montreal School Board and Quebec, and it's a consolidation of several challenges to Quebec's Bill 21, a bill that we've talked about many times before, which blocks public employees like teachers and police officers from wearing conspicuous religious symbols such as hijabs, turbans, and kippas. And I think few people doubt that the courts would have struck the law down for violating freedom of religion had Quebec not used the Notwithstanding clause to shield this law, which the Quebec government says is necessary to uphold their view on state secularism. So the applicants here are putting forward some Hail Mary arguments about why this law should be struck down, even though the Notwithstanding clause has been invoked. They're saying, for example, that this is entirely federal jurisdiction, which is a hard argument to make. They're also saying that certain old acts like the Quebec Act and the Hart Act, which said that Jews could be in the public service in Quebec, that these acts are also part of the Constitution and somehow override the Notwithstanding clause. But the real fight was expected to be around the question of whether, even if the law is going to stand, courts can substantively review it and issue a declaration that the rights have been violated. Something we've talked about again on this podcast a few times before, whether they can make a moot declaration. And the CCF was granted leave to intervene here to make some arguments to the court. So what we're saying is that regardless of that big question of whether a declaration is available, we think it would be not just inappropriate, which is the test for remedies under the Charter, to also go ahead and award damages. And there are other people, the BCCLA is at the court, arguing the opposite. They say that even though the law might stand, for example, Bill 21, people should still be able to sue the government and get money, which we think would undermine the whole purpose of Section 33 and just isn't what the Charter actually says. So I'm not going to get back into the arguments about whether declarations are available or not, because we've discussed that before. And the much more interesting news is this big bombshell that the Carney government dropped in their factum. So the federal government's not a party here, but like the CCF, they've been granted leave, or I think they have leave as of right, actually, to make arguments to assist the court in answering the questions. And last week we learned that they're going to be making some very novel arguments about, for example, that repeated uses of the notwithstanding clause could be illegal, and that uses of the notwithstanding clause that cause irreversible or irreparable harm could be illegal from the get-go and struck down by courts, or at least that's the implication. So Ottawa's argument here is that the 5-year sunset clause suggests that the notwithstanding clause is meant to be temporary. And so if a right is destroyed beyond repair, then it can't later be restored by a future legislature that doesn't want to use the notwithstanding clause. And the obvious counter argument here is that the text says the notwithstanding clause can be renewed with no textual limit on how often it can be renewed. So I've talked to a few lawyers and people who work in policy about what the Carney government is doing here with this argument. And one theory is that they seem to be setting themselves up to be the defenders of trans kids. Because if the court takes this up, trans rights groups could argue that preventing kids from taking puberty blockers, for example, will cause irreparable harm to their equality rights that can't be repaired when they turn 16. So it could be setting the Carney government up to be, the defenders of trans rights and trans kids against Premier Danielle Smith, or also Premier Scott Moe to a lesser degree. And if that sounds familiar, it's because Smith was often sort of the foil for Justin Trudeau in his later years. But I think this is really risky because if Smith can't even pass popular laws like, limiting puberty blockers, regardless of what you think about that, it's popular, because she's going to be blocked by federal courts, then it could hand an argument to the Alberta separatists that there's not much hope for them ruling themselves in Canada. And the argument about the repeated uses being potentially illegal is obviously antagonizing to Quebec, or at least to those Quebecers who support repeated uses, which the province has done for decades with its language laws, and was likely planning to do with Bill 21. The Bloc Québécois, unsurprisingly, has already put forward a motion in the House of Commons to condemn the use of this. And so it's clear Carney is picking a fight here with Quebec, or at least the Quebec nationalists. And so the question is why? At first, this seemed totally crazy to me, considering how much of Carney's base is in Quebec. But one theory I've heard put forward is that he's willing to stoke a little bit of separatism so that he can step in and play Captain Canada, especially if the Parti Québécois wins next year's provincial election. So it could be this sort of genius political move where you're stoking separatism in Alberta and also Quebec so that you can play Captain Canada. That's one theory I've heard. Another theory is that, maybe he didn't think this through. Maybe this was put forward by his principal secretary, David Lametti, who left the very same day this was filed. And Carney just sort of went along with the law nerds who really hate the notwithstanding clause. That's all speculation. I don't know what's really going on here, but just trying to figure it out. Another possibility is it's just a principled move because a lot of liberals, like I say, they believe that any use of the notwithstanding clause is by definition overriding rights, and that it's a legitimate thing. And so the federal government can try and get the court to box it in and limit its use at this opportunity. So no idea which one of those theories is correct. Joanna, do you have any leading theories? What do you think's going on here? Why do you think that they dropped this bombshell where they're asking the court to limit the use of the notwithstanding clause?
I don't know. I like the rampant speculation. I tend to kind of, revert to the simplest explanation that this is a clever lawyer's argument. Lawyers just like to come up with tests and frameworks and things, and just the whole thing about irreparable harm. Although we've talked about this, I'm not quite as convinced as you are that they're really driving at trans kids, although it's certainly possible. But this is just a lawyer's clever argument that really does have my former law dean, Lametti's fingerprints all over it. It's a very McGillian thing to do, and it just slipped the surly bonds of common sense. The factum from Ottawa reads like it was written by people who dislike Section 33 on principle and saw an opening here to advance a clever theory. But as you note, clever theories have consequences. This might be clever, but it's deeply unwise. And so they might win some plaudits in the seminar room, but they really are destabilizing the basic constitutional compromise, and they're handing kind of radioactive fresh ammunition both to Alberta populists and Quebec nationalists. So I say this is bad in law, bad in reading of the statute, and bad statecraft. Anything to add on? Oh, I also have a column about this in the Hub that came out yesterday during Rosh Hashanah, so I'm going to post it today. Yeah, you can see my take on that. I don't know if you have anything to add, Christine.
Yeah, I mean, I think that the Fed's interpretation here is clearly wrong. And one of the things I've been wondering about is, I have my criticisms of Justin Trudeau. And I know that Justin Trudeau, his comments about Bill 21 were kind of restrained for political reasons because that law is popular in Quebec. But I don't know that he would have accepted this argument from the attorney generals or from the Justice Department. Like, I think he might have had a better intuitive sense that this is unacceptable in Quebec, and not had this argument go forward. But I have no way of knowing, right? The feds have long said that they were going to leave all of their arguments about Section 33 and Bill 21 to when they make them at the Supreme Court. This kind of came out of nowhere, but maybe it was long in the works, and they just thought they would keep it going. Or perhaps there was some movement within the Justice Department that said maybe this is the time to push this forward because now Carney doesn't have that deep in his bones understanding of Quebecois politics and culture the way Trudeau, for all of his other inadequacies, definitely did. So who knows? Lots of interesting speculation and all kinds of theories, but I don't think it's something that we'll ever really know unless Lametti decides to sit down for coffee with Joanna and spill the beans to her. But I don't know if that's going to happen now that where is he off to? New York? I think he's the new appointment to the United Nations. So, I mean, I'm sure Joanna will have a lot of thoughts on that as well, given the UN's recent statements on Palestine and Canada's position and what Lametti's role might be in that. But let me move to my news headline, which is about the new federal liberal hate speech legislation. So this is Bill C9. It was introduced on Friday. It's formally called an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural places. But the short title is the Combating Hate Act. And the bill's not very long. I read it, but it does 5 main things. First, it repeals the requirement that the Attorney General consent to charges for hate propaganda offenses. Second, it creates an offense of willfully promoting hatred against any identifiable group by displaying certain symbols in a public place. Third, it creates a new standalone hate crime offense, similar to what C63 did. So if you commit any other offense and that offense is motivated by hatred, it's no longer a sentencing consideration. It is now its own standalone offense. And fourth, there are these what you might call bubble zone components, although we can disagree if they're actually a bubble zone law. So these provisions, the fourth and fifth thing the bill does is it creates an offense of intimidating a person from accessing a cultural or religious site, and it would create an offense of intentionally obstructing access to one of those sites. So I have a lot of problems with this legislation. I'll go through the proposals one by one to talk about what issues I have. So, first, removing Attorney General's consent. So, the bill would allow police to charge a person with hate speech without receiving the Attorney General's consent, which is an important safeguard for freedom of expression, and it has been part of our hate speech regime for decades. It's especially important given how nebulous and amorphous hate offenses are, and given the dangers in regulating speech. This was supposed to be kind of a bulwark against overreach. And it was like a guardrail against abuse. And now that is being removed. So I have a problem with that. I think that that should not be a part of this legislation. Second, the symbols provision is really troubling to me. I'm going to spend the most time talking about the symbols provisions. So, first, the symbols provision actually redefines hatred. It provides a statutory definition, which previously we didn't have. We just had a court common law definition of hatred. So, the bill defines hatred as the emotion that involves detestation or vilification and that is stronger than disdain or dislike. And that actually is not the court's definition, as per cases like Keegstra and Whatcott. And as problematic as it is to even try to define the term hatred, because it's always defined self-referentially and sort of circularly, even though it's a problem to try to define it at all like this, the definition is very watered down from what the case law says, which includes an element of extremeness. So in Whatcott, which is one of the leading decisions in this area of law, Justice Rothstein at paragraph 41 wrote, "The word hatred or hatred against must be interpreted as being restricted to those extreme manifestations of the emotion described by the words detestation and vilification. The term hatred or hatred against cannot be applied to every expression of repugnance, dislike, or offense. It must be restricted to those extreme manifestations of emotion described by the words detestation and vilification." This is the line where the court is stressing that hatred is the most extreme manifestation of negative emotion and not just dislike, ridicule, or offense. And the bill, it has a section that clarifies that it doesn't include speech that discredits, humiliates, hurts, or offends. But the problem is, supporters of these hate speech laws have always said that the statutory definition of hate is fine because it's drawn from the case law. And this actually isn't. They've removed the extreme component and they've actually lowered the standard. So I think that that's a really big red flag about what the government is trying to do here. They're trying to make hate offenses much more available, especially when you combine it with the removal of AG consent. The lower definitional threshold as well as the AG consent. I think that what they want is more hate speech offenses getting charged. Now, the other problem with the symbols component, there are a lot of problems. First is that it applies when you display a symbol in a public place. Now, can be debated, but I think that displaying one of these symbols on your private property, if it is visible to the public, would still be captured. And the state, the government has long wanted to go after the various cranks and fringe weirdos who fly hate symbols on their private property. You basically read a story like this about once a year about some weirdo flying a Nazi flag. And the response to these incidents has always been that is not a criminal offense. And obviously, I find that really disgusting behavior to fly a Nazi symbol on your property. But I don't think we should put people in jail because they are racist. I read a story just last night. When I say, you read about these once a year, I read one last night about a man just outside of St. Thomas, Ontario, who's actually being charged with mowing a swastika symbol into his lawn, like with his lawnmower. He was charged with various offenses, including public incitement of hatred. Now, we don't know all the details, but if the public incitement of hatred offense is just the lawn mowing, I don't think under the current law that is enough to charge him, even though he's been charged. And it shouldn't be. But under the new law, I actually think it could be. And I think that that's a problem. I'll get into why. So, but first, I'm going to talk about what is considered a hate symbol. So, the law actually lists swastika specifically, or the bill lists it explicitly. It says it includes a swastika as well as the SS bolt. That is in the proposed legislation. Other symbols are incorporated by reference. So, it includes a provision that says listed entities under the terrorist provisions of the criminal code are also hate symbols. These are, and this is a list that is updated regularly by cabinet. So symbols other than those Nazi symbols can be added, and removed without legislation. It's just done by cabinet. It right now, what the list includes is a lot of horrible organizations. Samadune, that weird BC organization that's kind of like pro-Hamas. Although I think they don't like being called that, but that's seems to be my interpretation of their perspective. It includes the Proud Boys, Adam Waffen, which is a white supremacist group. It includes the Tamil Tigers, the Kurdistan Workers' Party, which is a violent militant group in Turkey, I believe. It includes Boko Haram, which is an Islamic group from Nigeria, the Taliban, ISIS, Hezbollah, Hamas, various cartel organizations like Sinaloa, as well as Al Qaeda and many, many others that I have never heard of. So obviously all monstrous groups and disgusting. The public display of their symbols under this law would be banned as a criminal offense. And that's a problem because it gives all of these symbols a lot more power. It means also that we don't know who among various movements are actually harboring the views of these organizations. And it's actually very socially useful to know that. Someone might get attracted to a movement because it supports a certain cause. For example, rights of Tamil people in Sri Lanka. And you might say, I want more rights for Tamils in Sri Lanka. I'm going to join this protest and be a part of that protest movement. And that's how you get sucked into really dark extremist views, because you don't know that, for example, that movement that is appealing to you for a really legitimate cause might actually have a big extremist component in it that you were not aware of. And I'm just using that as an example. It just happens in all kinds of different movements. So you get lured in, can lure in young, naive people with good interests, good goals, and they can become radicalized, because you can never actually rid society of extremist thought, even if you ban extremist symbols. So we want to know who is in these groups, what they believe. We want to be able to condemn them socially and culturally. And we can only do that if we know who they are. Another issue I have with the symbols provisions is that they're overbroad. It prohibits symbols that resemble one of the prohibited symbols and that is likely to be confused with it. And honestly, that might sound like a weird, just hypothetical, but it actually happens all the time. It happened to me. I mean, I was at the library and I saw a car with a red swastika painted on the front. And I thought, oh my goodness, some Nazi has vandalized this car. But it turned out that it was a Hindu person who had put this on their car for some celebration. The swastika is a Hindu symbol for good fortune and well-being. And I think that wouldn't be prohibited by this law, but it would create a chilling effect. And as a Hindu person, you might say, I don't want to put this symbol on my car now because someone will complain to the police. I could get charged, even though it is protected. There have also been instances at various, pro-Palestinian or other Muslim dominant events where flags with Islamic proclamations are mixed up with terrorist flags. So, for example, the Hamas flag, the ISIS flag, a lot of other terrorist entities like Jabhat al-Nusra, which is a Al-Qaeda organization, and the Taliban, they all have an Islamic proclamation in Arabic of a phrase called the Shanda, which is a statement of Islamic faith. And uh, they all have this same writing on it. Um, but there are other flags that also have the Shanda on them that are obviously not a terrorist flag. For example, the flag of Saudi Arabia has this on it. So if you have a flag with the Shanda on it, you actually are always likely to confuse someone. And it happens quite a lot at these protests. And I don't think it's a good thing that we might create a chilling effect so that people who might, they wouldn't be captured by this law, but you could have a claim made against you that this is intended to confuse people. Um, as I said, there are legitimate reasons in the law. They have this defense provision, so you can display these symbols for what the government calls a legitimate purpose, like journalism, education, art, or religion. So that captures my Hindu example. But the problem is this chill. People may be afraid of being reported and confused, reported by confused people and confused police, because police often get confused about these hate crime provisions. Um, the other thing is that this exception only applies when the symbol, which is being displayed, the hate symbol, is not contrary to the public interest. And I just do not want the government and the police determining what journalism, what art, what education is contrary to the public interest. So those are some of my main concerns. I'll just really briefly tell you about my concerns in the other provisions, so that and I'll get the reactions from Josh and Joanna on all of this. So there's a standalone hate crime offense, which is part of the bill that was preserved from Bill C-63. They did make it a little bit better. So now if you commit an offense that the state says was motivated by hatred, it's a standalone offense with a high sentence, but C-63 gave a maximum of life imprisonment for these offenses. So they fixed that. Now it's 7 years, but that's still potentially extreme sentencing. So it means if you commit mischief, which is ordinarily a sentence of 2 years, you could now get a 7-year sentence if the government says it was motivated by hatred. The last part of the bill is what you might call the bubble zone provisions. Mark Carney had made a promise related to this. I don't know if this is even a bubble zone law. Josh, you think that they didn't even promise bubble zone laws. What this does is it prohibits intimidation, which is already illegal, and blockading, which is already illegal around these religious sites. So it's redundant. I think we shouldn't need redundant laws. And I've expressed some skepticism that blockading is actually happening when sites are being used for a religious purpose. I know that there are protests in front of some places of worship, but I'm a little bit skeptical based on the reporting that there are actual blockades taking place of people trying to access a worship service. But I'm open to being proved wrong about that. I just have not quite seen that play out the way it's being portrayed. But all of those things are already illegal. I don't really like redundant laws. I do have some concerns about how this gets enforced on the ground. But this part of it is not my biggest concern. One thing that's interesting about it is that Minister Fraser, who's in charge of this legislation, he said that the feds actually cannot do a bubble zone law because it's provincial jurisdiction. Josh, I know you have some thoughts on that because you actually think it's the opposite, and that's a political kind of cop out because they don't want to do it. Why don't you explain that?
Well,
And maybe tell me about what you think of some of the other proposals in C9.
I don't want to give them too many ideas, Christine, but I think if you look at the division of powers, if you're going to regulate hateful speech, and you look through the history of laws that do that sort of thing, that's criminal law, which is federal, right? So once you start restricting speech, that's federal law. So municipalities doing it, they'll say, well, we're doing this under our power to regulate, property rights, because that's a provincial power that municipalities have delegated to them. So I think that under division of powers, municipalities can't do bubble zones if they're aimed at speech, and that if anybody could do that, it would be the federal government. So I think they've got that backwards. And I do think that in these particular laws, intimidation or obstruction, those are the types of things that can be regulated without necessarily violating the charter. Whereas the municipalities that are doing these bubble zones, like Calgary's or Toronto's, they're very clearly targeting speech. They literally say you can't, perform an act of disapproval, or you can't, make some comment that is related to these particular speech topics. So those bubble zones are very clearly, in my opinion, unconstitutional. Whereas if you're targeting genuine intimidation and obstruction, yes, that's already illegal, so the law is redundant, but that's not likely to be unconstitutional. I do share a lot of your concerns too about this banning of symbols, because it's first of all, as awful as some symbols may be, they are speech at the end of the day. And in my opinion, we should never be banning speech based on its content, only on, the physical consequences that are immediate. So, inciting immediate violence against someone, but not saying something that is just essentially an idea. So I wish we could just keep that clear line, but we don't in Canada. So that's unfortunate. Yeah, so I think this law could be a lot worse, but there are several parts of it that are concerning, and so we're going to be pushing back. Joanna, I know you are concerned about other aspects of the law that maybe we haven't talked about that much. What is most worrying to you?
I just want to emphasize, well, I echo all of the concerns that Christine outlined really well. I think this law is not as bad as it could have been. I think definitely the watering down of the definition and the symbols. But we were, bracing ourselves because there were reports that we should expect a full-on federal bubble zone law. And, Sean Fraser was very clear that we can't ban peaceful conduct in specific areas. And I think that was just important to have underlined. Now, it looks like they're not necessarily condemning the bubble zone approach. We attended a technical briefing on Friday afternoon in which one of the Department of Justice staffers says that they see municipal and I suppose potentially provincial, but largely municipal bubble zones law as acting in a complementary fashion to this federal legislation. So they are not, necessarily on board with the critiques of bubble zone laws. Interestingly, you also brought up this point about the diluted definition of manifestations of hate, and the DOJ lawyer just completely denied that and said, well, it's meant to be read in context, blah, 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 which is just a classic Department of Justice, mealy mouth answer, because, you drafted the law the way you chose to draft it, and we have to read in some intentionality to that. And then finally, on the provisions about intimidation and preventing access, I agree they're redundant, but it does seem like there's enforcement problems. I talked about those last week. And so I am open to an argument that law enforcement needed a more distinct signal from the legislator to actually crack down on these things. But obviously that will come down to enforcement. So I would say it's a little more nuanced than purely redundant, because if cops are really confused about, how they should be enforcing the law, then maybe this is a signal. I'm not super optimistic about it, but I think we should stay open-minded to that. Anyways, let's take a break, and when we come back, we will talk about the state of Palestine. Okay, so as you have likely heard, Canada has just recognized the state of Palestine. And on paper, this sounds like a historic and even maybe principled moment, because there are Palestinian people and they are suffering, and they have not been able to organize their national aspirations into a form of recognized, organized statehood. But scratch beneath the surface, and the move really discloses, I think, a profound unseriousness because the quote unquote Palestine that Canada has recognized, along with a few other countries, including France and Australia, it exists largely, as Robin Urbeck put it in her column today, in the imagination of Geneva diplomats and has almost nothing to do with the reality or facts on the ground. So to set the scene, Prime Minister Carney defended his decision to recognize Palestine at the UN this week. He said it was necessary because the viability of a negotiated peace is being steadily eroded. And to his credit, he did cite that it's being eroded by Hamas, but also by the current government of Israel and Canada, alongside Britain, Austria, Portugal, and others, decided to recognize Palestine as a state in the hopes of reviving the two-state solution. And it's important to note that the earlier representation about this is that Canada's recognition would be contingent on the Palestinian Authority or Palestine or whatever meeting certain preconditions that they were never going to meet, like holding free and fair elections. So I found it pretty disturbing that they just got swept away and just dropped that without really even addressing it. Anyways, here's the problem. Canada has recognized a version of Palestine that just doesn't exist in any, in any sense of the word. The Palestinian Authority, which is named by Carney in his statement as the governing authority of Palestine, barely governs the West Bank. It hasn't held general elections in nearly 20 years. And it's widely understood that this is because there's so much popularity for Hamas, which is an internationally recognized terrorist group on the West Bank, which has only increased since October 7th. And Hamas, of course, remains in de facto control of Gaza. It recently carried out public executions on the street. We're recording this on Wednesday. This is reported to have happened on Sunday evening with suspected collaborators with Israel. And international law and political science usually point to basic markers of statehood, minimal markers of recognized statehood. And those are monopoly on the legitimate use of force, defined borders, and accountable institutions such as elections. Now, the Palestinian Authority indisputably possesses none of these. It does not control its borders. Borders are not agreed upon. It does not maintain a monopoly on violence. That is carried out by terrorist groups like PIJ and Hamas. And of course, the IDF has probably the strongest claim on monopoly of the use of force, for better or for worse, in the West Bank, at least. And it has not delivered democratic accountability. It hasn't even indicated like a 5-year plan to recognize democratic accountability. So recognition of Palestine as a state is not a legal acknowledgement of a state that exists. It is, of course, an aspirational gesture towards a state that might potentially exist one day. Now, Carney himself admitted that recognition is predicated on promises, reforms, demilitarization, the exclusion of Hamas from elections, but promises and, how this could work in notion are not sovereignty. Promises don't create institutions or disarm militias, and promises from a governing body that hasn't managed to hold an election since 2006 are very thin gruel. It's now even worse, to add insult to injury, but very predictably, Hamas has explicitly claimed that these recognitions are the fruits of October 7th. For them, it's vindication of their tactics of terror, violence, torture, rape, kidnapping. So while Carney is insisting that Canada's gesture is in no way legitimizing terrorism, it's just important to acknowledge that that is not how it's being read on Hamas Telegram propaganda channels in Gaza, or indeed most likely in the West Bank. And when terrorists claim a prize, it doesn't matter if you say it's not meant to be a prize. You've handed them legitimacy. This is also a real radical departure from the Western diplomatic consensus on the Israeli-Arab problem or the Israeli-Palestinian problem. I think it's more accurate to call it the Israeli-Arab problem at this point, because clearly the Arab world needs to start taking this seriously. But the consensus was clear. The recognition of Palestinian statehood would follow a negotiated peace, and it would not precede it. The recognition was supposed to be the result of peace and not a bargaining chip thrown in before talks even begin. And by reversing this sequence, Canada and its allies in this move have given up important leverage. Israel, for example, has one less incentive to negotiate. This is just raising even more skepticism amongst Israelis, even Israeli liberals, by the way. My fiance and his family are in that camp. Like, I can tell you, Israelis, DGAF, like, this is so remote and so out of left field to them. And of course, Hamas has one more reason to claim victory. And the result is that Canada has managed to alienate both sides. Supporters of Israel see this as a reward for terrorism. Supporters of Palestine, I was just reading, I haven't actually read it through yet, but there's an op-ed by Mustafa Barghouti, who is founder of Palestinian National Initiative based in Ramallah. And he sees this as just a hollow recognition. It doesn't come with any real strings attached, cutting ties to Israel or establishing full diplomatic relations. So, in trying to please everyone, or at least signal virtue to international partners, which I think is really what's going on here, Mark Carney likes to see him in a peer group with the UK and with Britain. Canada's pleasing no one except Hamas, basically. So, to sum up, foreign policy should be grounded in reality and the rule of law, not in the fantasies of Geneva. Recognition of a state that lacks sovereignty, elections, control over its own territory is not recognition of reality. It's a fiction that has consequences, that undermines negotiations and makes Canada look deeply unserious on the world stage. So I think if we care about the rule of law, and if we care just about like basically staying in touch with reality, we have to resist the temptation to substitute wishful thinking and impose our own pre-existing frameworks onto a region that has told us time and time again on both sides. Unfortunately, the reality is there's no appetite on either the Palestinian or the Israeli side to talk about a two-state solution right now. But you have to start from reality. You don't build peace by recognizing fantasies, but by recognizing facts. Josh, you were noting, I actually couldn't bring myself to watch it. There's a clip of our minister, Anita Anand, standing up and cheering at Carney's speech at the UN. Do you have anything else to say about this?
Oh yeah, I have lots to say. I thought that clip was sickening, frankly. I think that what the government is doing is rewarding Hamas, and they know it. Their position will be that, well, no, we're just, siding with the Palestinian Authority, and we're going to, help them so that they can somehow get rid of Hamas, which they haven't been able to do for decades. But the thing is, like, there's this weird belief, I think, that a lot of Canadians and people in the West seem to have, that somehow the Palestinian Authority and Fatah are the good guys, and that, it's just Hamas that's bad, and as long as the PA is in control, then things will be fine. But the Palestinian Authority supports terrorism. Like, the Fatah supports terrorism. There's no question about this. Like, they've been in charge of the West Bank for decades. I don't know how long Abbas has been there, but he's essentially a dictator. And Europe and the West was trying to pressure Fatah to be less pro-terrorism, and one of the ways that they wanted them to do this is to stop printing in the textbooks that countries like Canada generously fund. We announced $47 million more for them literally today at the UN, to stop being so anti-Semitic in their textbooks, so that they can convince their population that the PA is the good guys. Well, they did not. They have new textbooks that came out last year. The grade 11 history textbook says Jews control the world. It has iconography of a hand bearing a Star of David gripping the globe. And then there's the Islamic education textbook, which says Jews are deceitful manipulators who attempted to lead the Prophet Muhammad away from faith. The textbook promotes jihad. The textbook says Palestinians killed by the Zionists are martyrs, and that one day there will be a rebirth and a new dawn, and that they'll return to their sacred homeland in the heavens if they become martyrs. Like this, it's as bad as you could expect, as anti-Semitic and pro-terrorism as it could possibly be. And the PA has also had the pay for slay policy in place for decades, and the US withdrew funding because they will literally pay the children and the wife of people who blow themselves up or kill the Israelis or Americans. They'll literally pay them for the rest of their lives a giant pension with, again, our money. And this constitutes a huge part of their budget, is just pay for slay, which they've just refused to end. So I don't know why people seem to think that, while Hamas is bad, that the PA is somehow going to be better and that there will be some sort of democratic state. It's just not going to happen. So yeah, I think this was for crass domestic political reasons that this was done, and I find it really disgusting, frankly. Christine.
I'll just add one thing, which is, Joanna, it seems like you might be in agreement with one of Canada's most hated online personalities, Rachel Gilmore, because she tweeted that, in criticism of Canada's recognition of a Palestinian statehood, that Canada is putting conditions on the recognition of self-determination, tweeting out about how, that's it. She was retweeting herself and a news release about how one of the conditions is that Hamas may not govern. Now, I think you come at it from different perspectives, because it seems like you don't think Hamas should govern, and that the inability of the state to exist without Hamas being a part of that government is part of the problem of why the state cannot be recognized. I think Rachel might have a different perspective, but you both seem to think that not recognizing so the self-determination, which would be Hamas, is a problem, an inherent problem in statehood. I don't know if you want to respond to Rachel. But yeah, that's sort of her perspective as well.
Yeah, people are pissed off on both sides, and I follow a few pretty hardline Palestinian influencers just because I like to see what they're saying. And another line that I've seen, which I'm sure you guys can see coming, is they're recognizing Palestine as Gaza and the West Bank, but all of Israel is Palestine. I've seen that as another very common critique. So yeah, they're not really making friends with anyone on either side. And Barghouti is seen as a relative moderate in terms of PA stuff. So yeah, it's just this club of dumb diplomats in suits, basically.
It's a valid point that if you do not have self-determination, you're not a state. I mean, it's kind of the point. The same point is just that you think they should not be recognized for that reason. So let me turn to my bad legal take this week. I'm going to turn to something local, a pet peeve of mine, in fact. And my bad legal take is going to Doug Ford, Ontario's premier, for claiming victory for getting rid of the speed cameras that he basically created. Now, I hate speed cameras because they give me tickets. But they were basically enabled because in 2019, Ford empowered municipalities to install these speed cameras, specifically in school zones and what are called community safety zones, basically areas with a speed limit of under 80. Obviously, there were a lot of complaints, not just from me, but a lot of people got tickets from these cameras. Some of them get repeatedly vandalized. There's one in my neighborhood that keeps getting knocked over by some local hero. because they're really unpopular. And there is nothing that Doug Ford hates more than being unpopular. So now he is saying that these cameras are terrible, that they are a tax grab. He also said if municipalities don't remove them voluntarily, the provincial government will, quote, help or somehow force them to do so. He's done a couple things already. For example, the 2025 budget included the ability of the province to set criteria for when a community safety zone can be designated and will possibly be regulating the threshold for issuing tickets. But now Ford is hinting he's going to do even more to get rid of these cameras. And I just think that Ford cannot claim a political victory for undoing a law that he created himself. So my bad legal take goes to Ford for creating and then criticizing his own laws. Josh?
So my bad legal take goes to the public safety minister, Gary Anandasangari, who has put his foot in his mouth many, many, many times in the past few months already, but this one is especially bad in my opinion. So the public safety minister was recorded recently in a conversation he had with a tenant at one of his properties who was concerned about the federal Liberal government's buyback program, or I don't know if it's fair to call it a buyback since they never owned the guns in the first place, but their plan to essentially force people to hand over certain weapons that they say are dangerous and will become prohibited as soon as their current amnesty ends. And this is something they've been working on for years, and they haven't even begun taking the guns back. But in any event, so the minister was speaking, didn't realize he's being recorded, and the tenant was concerned that he was going to have police barge in and charge him for having a firearm. And the minister tried to assure him that no, this wouldn't happen, and that the program is voluntary, and that if police really did barge in, he would be the first to bail him out. Well, that's just not true. That's just not how it works. The program may be technically voluntary in one sense, but as soon as the amnesty is over, assuming they do end the amnesty, you would be a criminal if you had one of these guns. And maybe there won't be police actively going and getting them, but if somebody heard there was a gun there and called the police, you would be going to jail. You would be going to prison. It's very, very serious stuff. And then Ananda Sangari held a press conference this week where, I think he was expected to fix this mistake, and he repeated it. He told a reporter, the program is voluntary. No one is having their weapon confiscated. Well, that's just not true. The program is only voluntary in the sense that you have a couple of other options, which is to destroy the gun or to export it. But the presumed option that almost everyone will take is that they will sign up with the police and hand over their weapons in exchange for a very small amount of cash. So I think this is dangerous. I don't think the minister should be suggesting this is in any way voluntary when these are prohibited weapons, and that's a very serious criminal offense as soon as the amnesty is over. So bad legal take to the public safety minister, Gary Anandasangari. Joanna, let's hear yours.
Okay, my bad legal take goes to Viva Fry, the online pundit, who tweeted about news of an ostrich cull in BC with the quote, "The Canadian government is a terrorist organization." Now, obviously, he's blowing smoke. This is hyperbolic. He thrives on provocation. He knows he's not actually filing a legal brief with CSIS here, but there's been a lot of this reaction going on the internet. So let's just remind listeners what happened. So an ostrich farm in BC, and Josh gave a really good breakdown of this a couple months back, had its flock ordered culled after tests confirmed cases of highly pathogenic bird flu. The Canadian Food Inspection Agency, following its mandate under the Health of Animals Act, moved in to prevent spread to other poultry operations, as well as potentially humans. This was not random sadism. And of course, terrorism has a specific definition. It needs a political objective, an attempt to spread fear. And now, obviously, Viva Frei is not really trying to apply the criminal code. But you can absolutely debate whether the CFIA could have tried less destructive containment measures. It also seems to be the case that no measures were taken to quarantine the birds, the ostriches on the farm. Maybe they could have pushed for better testing, maybe push them for quarantines. Those are legitimate questions of proportionality and necessity. But this whole ostrich farm incident has become a real shibboleth of certain sectors of the internet. But let's not get beyond ourselves. This is not a war crime.
Or terrorism.
Or terrorism.
All right, that's the end of the show. I made it through the show despite my horrendous back pain, so very proud of myself. Thanks everybody for listening. If you haven't rated us or reviewed us, please consider doing so because it helps us out a lot. The CCF is a nonpartisan legal charity funded by your donations, so please do click that donate button on our website if you can. Thanks for listening.